Okay, so thank you all for joining us. I'm delighted you're able to attend this this exciting session. Want to briefly first acknowledge my wonderful colleagues who are co-sponsoring this event. My name is Randall Obaid, and I'm the Assistant Dean for the Environmental and Energy Law Program at GW Law, and we are co-sponsoring this session with the International and Comparative Law Program at GW Law. And we are fortunate to have with us today Associate Dean Rosa Solorio of that program and Professor Leah Calabro in that program. So they were certainly wonderful partners in making this event possible. And I certainly want to just say at the outset just how delighted we are to have Professor Bhardwaj join us from Jindal Global Law School. And I want to briefly give you a snapshot of her background before we have her begin. So Professor Chhaya Bhardwaj is an Associate Professor of Law at the OP Jindal Global University and a member of the International Union for Conservation of Nature and the Sabin Center for Climate Change Law at Columbia University. She was a visiting researcher and lecturer at Dublin University just this past December and January. And she has received her BA and LLB from Chaudhary Charan Singh University, Meerut. And she received an International Environmental Law Fellowship Award to pursue her LLM at Vermont Law School, my alma mater. So that's very exciting to hear. She also received a United Nations Fellowship in 2017 to pursue a regional course in international law from the United Nations Office of Legal Affairs. Her teaching and research are at the intersection of law, environment, and climate change. She writes on environmental laws, disaster laws, climate change and human rights, international law and climate change and law of the sea, climate change and refugee law, and climate change and migration law. So we are really very much alike that way, as I describe my area of expertise as climate change. And I think you just heard that I have a partner in crime in that space. So I'm just delighted that Professor Bhardwaj can join us today on this very important and cutting edge topic. And while she is speaking, I'll put in the chat the link to the article that she has published on which this presentation is based today. So we will hear for about 30 minutes the presentation, and we will have ample time for Q&A at the conclusion of the presentation. But feel free to put your questions or comments in the chat as we go. So Chhaya, the floor is yours.
Thank you so much, Professor Bhate. I am actually excited about this presentation and also excited to be a partner in crime on issues related to climate change and cross-border migration. So the presentation today is about climate change and cross-border migration and the Biden administration. I'll be concluding with what the future holds, not just in relation to Biden administration, but also the future administration that might come in the United States. The objective of this presentation is fourfold, although I will not be going too much into detail about all of these. So the first one is to understand the scientific and factual assertions that are there in the climate change migration report prepared by the US Department of State 2021. First, we understand what are the scientific and factual assertions in that particular report. Then we move on to the legal frameworks that have historically existed in international law and in the US, linking them with the existing laws, and then concluding with the challenges that are there in the existing laws, coming finally to way forward. All right, so the executive order that Biden administration came out with, the 14013 executive order, which was titled Rebuilding and Enhancing Programs to Resettle Refugees and Planning for the Impact of Climate Change and Migration. So after this executive order, the the Biden administration essentially wanted to focus on finding interlinkages between climate change and migration, not just cross-border migration, but also internal migration. But the focus of the Executive Order 1401 was to look at cross-border migrations and link refugee-related frameworks or refugee-related planning within the United States. And so they thought the first step to integrating climate change and migration is to prepare a report, understand the state of the affair of the science and the geography and the economics that is there in relation to climate change, its impact on migration, including forced migration. And so when the report came out in 2021, the report confirmed the linkages between human mobility, and I'm using this broad term, mobility essentially means movement. So the report confirmed linkages between human mobility / movement and climate change. And the linkages were very wide and broad, confirmed linkages that were voluntary enforced both in nature. And so apart from this horizontal linkage, there were also vertical linkages, meaning that the movement of humans was also connected within a sovereign state and across sovereign states. So it confirmed linkages between cross-border migration and migration that happens within the country due to climate change and extreme weather events. I think the Californian floods that are impacting United States right now would be an example to assert internal migration that is happening because of climate change and extreme weather events. The report also took a lot of scientific material from the Intergovernmental Panel on Climate Change, which is the sixth assessment report, also confirming similar linkages. Now, one of the first things that the report talks about is connection between climate change and violence, or climate change and conflict. And on the issue of whether climate change is driving conflicts or climate change is exacerbating resource scarcity related violence or conflict, the report does not conclude anything with certainty. The report takes example of the Sahelian region from Africa, where because of desertification, droughts, the farming community is increasingly facing seasonal migration. But in that Sahelian region, we also notice trends of violence which are only recent in nature. And so what the report says is that climate change definitely adds to conflicts or violence that happens in communities. However, climate change is not a direct driver of conflict, or nothing has happened yet to conclude that climate change is a direct driver of conflict. Because if that was the conclusion, another conclusion would have been that climate change and conflicts are linked, and therefore conflict-related displacement can also be attributable to climate change. The second thing that the report talks about is that climate change migration is inducing political instability. What this means is that climate change is causing a lot of democratic institutions to come under pressure because of migration. And how does that happen? We've seen with refugee migrants coming into one country, the paranoia or the fear over exacerbating resource inequalities or stress over public budgets, xenophobia, increases political tensions. And generally, whenever there is a framework or there is a policy accepting immigrants into any country around the world, anti-migration political actors become more vocal and they become trending against the large group of migration flows that are incoming. And so as policy responses, it is important, and the report also recognizes this, that policy responses in the developed world, meaning developed world like the United States, which is considered to be one of the most developed countries in the world, will have a direct impact on political responses and stability everywhere. And so it is important that today US develops a political response or a policy response in relation to climate change, cross-border migration. Now, another challenge that the report highlights is that another political instability is also linked with non-state armed actors. Non-state armed actors or violent extremist organizations can majorly take advantage of the gaps that are there because of climate change related resource scarcity or climate change related inequalities. And these violent extremist organizations can also generally exacerbate negative effects that are linked with human trafficking, illegal mining, resource exploitation, so on and so forth. Now, looking forward, the report says that migration can be seen as a form of adaptation to the impacts of climate change. Migration is also a response to climate change threats to well-being, and that US can particularly look at developing early warning systems to monitor climate change impacts and to compound climate related migration. Now, this is the scientific assertion. Now, this is what the science is saying. Science is trying to link various impacts of climate change. And now we're moving forward to establishing linkages between climate change, cross-border migration, and international law. And then we'll come to the US domestic laws. Why I'm doing this is to make you understand the emerging trends that have been there both globally and nationally in the US, and how the trends in both the laws have affected and impacted each other. Now, if we look at the history of international law to protect forced cross-border migrants, we see that 1951 Refugee Convention was the historic win to protect people that were displaced because of persecution in their country of origin. Now, when we look at the 1951 Refugee Convention, it protected very specific people who were affected because of World War II, and specifically in Europe. So we see that initially, when we see the language of who would be protected under the 1951 Refugee Convention, it was very Eurocentric. One example to highlight would be the 1951 Refugee Convention only protected people who were affected because of World War II. And this means they ignored a very huge population that was at risk of persecution and similar human rights violations, for example, at India-Pakistan border. So 1947, India-Pakistan also witnessed partition. And there were a lot of people who were migrating across borders, meaning from India to Pakistan or Pakistan to India. And those people were largely not covered by the 1951 Refugee Convention because of its specific definition. So 1951 Refugee Convention was largely or is largely known as Eurocentric, aimed at protecting people only of European origin. Later, the 1951 Convention was amended to protect people from all nationalities. And that happened with the 1967 protocol that was attached with the 1951 Convention. Now, so this challenge of Eurocentricity was definitely addressed by the 1951 Refugee Convention, but the 1951 Convention today has another challenge for which it is criticized again and again, and that challenge is that the 1951 Convention does not protect people who are displaced due to factors of natural calamity, disasters, environmental degradation, or climate change. Because the essential claim under the 1951 Refugee Convention should arise on grounds of persecution, and natural disasters, environmental degradation, floods are not persecutors or agents of persecution. So that is a challenge that remains. Now here I'm talking about a time period of 1950s. What happened in the US in relation to cross-border migrant protection in 1950s in the US? Now, US was in fact very progressive in comparison to international standards when it comes to protection of cross-border migrants. And if you look at the first US immigration law that was named the Refugee Relief Act of 1953, they had provisions to protect people affected by natural calamity. So here we see that the US is departing from the international standard, and instead of making its domestic policy narrower, US is in fact making its domestic policy broader in comparison to the international standard. Then in 1958, we see a common trend that the 1951 Refugee Convention also followed, was that the United States drafted the Azoran Refugee Act to protect European population from natural calamities or disasters. Now, when I'm saying European population, I'm specifically referring to the Portuguese citizen. The Portugal citizens were protected under the Azoran Refugee Act because they were suffering because of a natural calamity, more specifically a volcanic eruption in the 1950s. And so these were the specific laws that were trending in the US in the 1950s. Definitely a departure from the internationally accepted standards of protection. The US generally is not famous for following the climate change related standards and international law. This being a departure because US definitely broadened its horizons to become more environmentally accepting, especially for the countries. Moving forward to the current international law to protect cross-border climate change migrants, I've already highlighted that the 1951 Refugee Convention does not protect people displaced due to climate change. This also means that currently there's no international law that says protect climate refugees, or these are the standards to protect climate refugees. In fact, if I can claim, there's no concept of climate refugees under international law as of today. The human rights treaties, like the International Covenant, there's a typographical error there. International Covenant on the Civil and Political Rights may protect people displaced across borders due to climate change, but this standard has not been applied yet. However, the Human Rights Committee, one of the sub-organs of the Human Rights Treaty, it is one of the human rights treaty bodies aimed at judicially protecting human rights internationally, has accepted the interlinkages between climate change and human rights. So these are these two cases wherein the Human Rights Committee has accepted the interlinkages between climate change and human rights, specifically right to life under the International Covenant on Civil and Political Rights. These two cases are Tishiota v. New Zealand, 2020, and Daniel Billy et al. V. Australia, 2022. Now, if you look at the Tishiota's case, or if you've read Tishiota case ever before, you'd know that Tishiota was a Kiribati citizen, is a Kiribati citizen, and he had moved to the New Zealand, where he was facing deportation. But he said, "Do not deport me." He requested New Zealand government to not deport him and his family back to Kiribati because Kiribati is facing inundation due to sea level rise. And then he approached the Human Rights Committee asking or requesting the Human Rights Committee to decide that New Zealand will be violating Tishiota and his family's right to life if he's deported back to New Zealand. But in this case, the Human Rights Committee did not recognize Tishiota as a climate refugee or somebody who can be protected under the standard of right to life. The reason that was given both in Tishiota's case and Daniel Billy's case in relation to climate change protection and its linkages with right to life was that sea level rise is happening, but it's not an immediate threat. And whenever there's a right to life standard, if a judicial body has to apply a right to life violation, the standard to decide whether there is a right to life violation or not is dependent upon two broad standards. The first standard is imminent threat, and the second standard is foreseeable risk to life that may or may not be preventable. Now, in relation to the first standard, that is imminent threat, the court said, or the committee said, that both in Toyota and Daniel Billy, the sea level rise is happening and it may inundate the island in next 10 to 15 years. And so 10 to 15 years of time frame would not qualify as an imminent threat to establish a violation of right to life. And this is what the holding is in both of these cases. And therefore, even with a clear linkage between climate change and human right, they have not been able to establish a right to life violation and protect these people. In fact, in Toyota, the court has also recognized the fact that sea level rise is a slow onset disaster, meaning it is happening slowly and steadily as we talk about it. And it is not a sudden onset disaster like an earthquake, which will happen at the blink of a second and would be more likely to help a claimant establish a right to life violation. And so this was the first standard. The second standard of foreseeability would be that even though sea level rise or risks arising out of sea level rise and inundation are foreseeable, but at the same time, they are preventable by the state. And so if the state is consciously taking actions to prevent sea level rise or to protect people from the adverse impacts of sea level rise, a direct claim cannot be established that the state is violating claimants' right to life. So these are the two challenges that are existing right now in relation to, in the context of application of human rights standards to protect cross-border climate change migrants, and in fact, in Daniela Billy case, to protect the internal migrants because of climate change. However, one good thing that has happened because of Daniel Billy cases, that a state can be held responsible if the state fails to take adaptation measures to protect people from climate change and sea level rise. And so today, if I'm saying that the US government has recognized migration as an adaptation tool, and if the US government is not able to use migration as an adaptation tool, it may lead to violations of human rights under the International Covenant on Civil and Political Rights. This is the international standard that is there right now. Although no concept of climate refugees and no very specific rule-based standard to say you apply this and you protect a cross-border migrant, you protect the rights of a cross-border migrant, nothing like that. Again, I would say United States laws are, again, more formalized and codified in comparison to the international standard, because when I look at the US laws, there are three different regimes that I can see to protect people who are affected by natural calamities, disasters, or climate change in their country of origin. The first one would be humanitarian visas, which can be given to people who are affected by environmental disasters or emergencies in their country of origin. The next is humanitarian visas. The next one is temporary protected status, the TPS, which can be given to people who are immigrants in the United States when a calamity happens in their country of origin. So say, for example, when the Turkey-Syrian earthquake happened, if there were Turkey-Syrian citizens who were present in the US as immigrants, they could have been protected under the temporary protected status. So by declaration or by notification, the government of the United States can put people who are affected because of the Turkey-Syrian earthquakes under the temporary protected status list. Now, Asian countries like Nepal have received TPS protection, but largely countries from Asia do not remain beneficiaries of the TPS protection. Then the third one is deferred enforced departure. Now, deferred enforced departure, the DED mechanism, is the executive power of the president to stay removal of immigrants present in the US soil through an executive order. It's largely discretionary in nature, but the DED has never been used till date to protect people who are affected because of natural calamity or disasters in their country of origin. Now, these are the present US laws. And like I said, they have been applied in the past to protect people. They've been applied in the past to protect the Portuguese citizens from volcanic eruption. They've been applied in the past to protect the Haitian citizens who were affected because of the 2010 earthquake. They have been applied in the past to also protect citizens from other countries who were affected because of natural calamities or disasters. The challenges to the present law in the US, however, remain. Now, the first challenge is that these protections haven't been extended to people who were or are similarly affected by extreme disasters. And an example of this would be the tsunami that affected the Asian countries by and large. So the United States government decided to protect people who were affected because of earthquake in Haiti, but largely ignored people who were affected by tsunami. And so, although of course this is a domestic decision by the United States government, but the rationale as to why United States decided to protect one country which was in similar situation and decided not to protect citizens who were in a similar situation affected because of extreme disasters. So the similar standard was not applied. The second challenge is that the creation of a Zorian Act to protect Europeans was a fantastic example set by a developed nation. However, no other similar measure has been taken after the 1950s to protect people from other regions. And this particular decision can be perceived as Eurocentric. And there can be claims that the actions of the United States government to protect people in extreme disaster situation has been largely Eurocentric. The third challenge is that the changes in administration within the United States can also be threatening to ending protections for some of these groups. For example, the Trump administration sought to terminate the TPS protection for El Salvador, Haiti, Nicaragua, which then led to judicial review of the decisions. And therefore, I think the political changes, as was highlighted by the report as well, the political changes can also be challenging for protection of such people. The fourth challenge, and I already highlighted this, was that the DED departure, deferred enforced departure hasn't been extended yet to people affected by natural disasters or extreme disasters. I apologize for the use of the term natural disasters. For those of you who are in the field, some of you may hold the opinion that natural disasters are technically incorrect phrase to use. And then the final challenge is that Currently, Biden administration has talked a lot about protecting people affected due to climate change, but hasn't really taken any concrete action to apply even the existing laws to protect people. For example, there was some talk about or some recommendation to protect people affected by Pakistan floods, which was really extreme in nature. One third of Pakistan was affected because of the floods that were directly a consequence of climate change, wasn't really taken note of by the Biden administration. Again, people currently are affected by the earthquakes in Turkey and Syria, and while the administration can take certain actions, it is not. I'd just like to highlight one really good practice that I've seen both in Canada and the US is that in some of these countries which are affected by disasters, both Canada and US come out with child adoption programs for children who have lost both of their parents because of disasters. And I think this is one good practice that again I've seen both from the Canadian government and the US government. Again, my criticism to it would be that it is not similarly applied to countries in similar situations or similarly affected by extreme disasters. All right, so the other challenges to protection of people who are suffering because of extreme disasters in their country of origin comes from other laws. And these laws are listed here on the screen: the Illegal Immigration Reform and Immigrant Responsibility Act, the history of exclusionary acts in the US, like Chinese Exclusion Act or the Immigration Act that banned people from Asia Pacific to the entry of the United States. And then the 1996 Anti-Terrorism Effective Death Penalty Act. There are claims and empirical studies to show that the effect of a lot of these additional acts has been to create or at least to tag immigrants as criminal, and a lot of it has motivated anti-immigrant position of anti-immigrant political actors. And so I'm not claiming that these acts essentially are criminalizing immigrants, but the effect of these acts is empirically known to have been criminalizing immigrants. And then there is a lot of changed perception after the 9/11 attacks for immigrants, particularly from Islamic countries or Muslim countries. And one example of it would be Pakistan. And so one presumably valid rationale for not including Pakistan within the protected status could be this changed perception to Islamic countries, Islamic states. And also the general positioning of Pakistan in terms to violent and terrorist activities just globally. And so that could be one of the rationales. The conclusion of the presentation, I would just reiterate what I've stated earlier. I would state that there are linkages between climate change and migration. They are undeniable now, as we are at the end of the sixth assessment cycle of the Intergovernmental Panel on Climate Change. And so I think this is the time where science is as stronger as it can be in terms of establishing these interlinkages. Secondly, the report itself is recommending that there is a need for national frameworks to integrate the challenges into the solution. And if the Biden administration really follows the report, they are likely to follow this path. But until now, the lack of any concrete action doesn't show or reflect political intention to really act on the report. And then finally, international standards on linkages between migration and climate change that are emerging from the human rights field can also guide some of the national framework that will be happening, not just at the US, but at other countries as well. So what is the way forward? These are largely recommendations that are there in the report. And some of the recommendations are that I have incorporated. We could definitely talk about assistance to support migrants, displaced persons, and their host communities, divesting away from fossil fuel-focused development, using climate information, decision-making, designing programs that support adaptation to climate change. And all of this should be done keeping in mind the internal displacement as well. And because extreme weather events are not just affecting other countries, but extreme weather events and sea level rise is also affecting US as well. And we can see it as we talk about it. And conclusively, I would like to highlight that geographies would become very important in the context of climate change as we deliberate upon it from today. Because keeping in mind the geographies and the regional consideration for those who are affected by extreme weather events and climate change would be integrated into the overall policy making and framework making. Because the top 5 countries with the largest land areas in the world, like the United States, can share higher responsibility for including climate change induced displaced persons. And to conclude and to open the floor for questions, just want to give you a context that Nauru is one of the smallest island developing nations, which has an area of 21 kilometers square. One of the countries that is likely to lose its land completely or lose its status as a nation in some decades in future. And the United States has an area of more than 9 million kilometers square as we talk about it. So this is geographical disparities that are there naturally, but because of the anthropocentric climate change and because of human actions by some of the individuals, corporate fossil fuel actors, and developed countries, the gap between the small island developing nations, the land that a small island developing nation has, and a land that the top 5 countries have is only going to increase. And so this is not going to decrease anytime in the near future. And so I think this disparity, geographical disparity, should also be taken into consideration while we develop policies and discuss way forward. So that is my time for the presentation. Thank you so much.
Thank you so much, Chhaya, for that outstanding presentation. Really touched on so many important themes. And you'll see in the chat that it inspired me to have a 30-minute conversation with myself. So I invite you to join that conversation. But I wanted to prime some ideas in our audience, perhaps, but I'm sure they've got many questions of their own too. So I'd like to open the floor for anyone who would like to ask a question directly rather than posing it in the chat. Ashini, we can't hear you.
How's that?
There we go.
Great, thank you. Hi, Professor. Thank you so much for taking the time to speak to us today. I really appreciated your lecture and really found it fascinating. I wanted to learn a little bit more about your thoughts on policy and protections afforded for internal versus transboundary migrants. You touched on that briefly, but I imagine they require vastly different protections and assimilation techniques from governments. And so kind of how you see that, and if you think they should be divided into different categories, or if you think that some sort of climate migrant policy could encompass both internally and transboundary.
Thank you for your question, Ashini. My answer to your question is twofold. There are similarities to protecting both cross-border migrants and internal migrants, and there are differences in protecting them as well. And I think this difference and similarity arises from the fact concerning what kind of disaster they are affected from. And so let me give you an example. If it is sea level rise, and say if I'm talking about Florida or Louisiana, the Delta region of Louisiana is facing a lot of erosion because of sea level rise and the connection of the river tributaries that are there. So I'm talking about effects because of sea level rise and climate change in the state of Louisiana. They are slowly progressing, but at the same time, they would be permanent in nature. But if I'm talking about effects that come from floods, they would be sudden but temporary in nature, right? And so both the similarities and differences in protection will come from these scientific factual assertions. So even for cross-border internal migrants, we'll have to look at, say, people who would be displaced because of complete or partial inundation of a small island developing state like Nauru. So when Nauru loses half of its land because of sea level rise, or all of its land because of sea level rise, it means that the displacement would be of permanent in nature. And so these people would need different sort of protection. But if I'm saying Turkey Syrian earthquake happened, and say they'll require next 5 years to build themselves back better, so on and so forth, this sort of cross-border displacement can be categorized as temporary, and a lot of these people might just want to go back, assimilate into their culture and where they were raised, and they would want to go back. And so similar differences would be there for internal migration as well. And then, of course, the discriminatory characters also remain the same. People of color, again, both internally and cross-border migrants would probably would want to receive a different sort of protection, and there may be discriminatory behaviors that may or may not arise because of these challenges. And so this is my twofold answer. But again, from legal perspective, just highlighting one thing: cross-border. So US does not have any obligation to really protect people from other countries. But that is a difference that is there for its own citizens. It has a stronger obligation to protect its own citizens. So people who are affected in Louisiana because of sea level rise, or people who are affected because of floods in California, would be the first priority for the US. And so in this process, of course, the standard would be protect your own citizens first if there's a disaster or crisis happening, instead of protecting cross-border migrants. And so that would be a differential standard. And other, again, it's a complex issue. I can keep talking about it, but just to highlight these fundamental differences. Thank you.
Thank you very much. That's very helpful.
Other questions, comments? I've got plenty that I can raise out of.
Is there any other question?
Yeah, I've included many in the chat just in case we had a lull, but I certainly want to give the rest of the audience an opportunity.
Professor, I think I can't hear you because of some reason.
Oh,
Okay, now you're audible. Sorry, apologies. The internet is lagging here, so sorry about it.
oh, no worries. So yeah, I was just saying that I had plenty of questions in the chat that I can pose to you if we don't have any other questions or comments from the rest of the audience. Okay, I guess I'll do that. So One of them was the idea of the terminology to use to identify what are typically called climate refugees, but there are other terms out there, climate migrants, climate displaced peoples. And I was wondering about your opinion about which of those terms is best suited to enhance the protection for these vulnerable communities.
Thank you for your question, Professor Bhate. Just technically speaking, I think I would reassert my claim that there's no legal concept of climate refugees under international law as such as we talk about today, because whenever we speak about refugees, we customarily speak about refugees in terms of persecution at hand that may arise. And so the challenge here would be to identify what a persecution would be, or who would be a persecutor for climate refugees. And of course, these are just technical debates that may or may not be there. But if there is a legal jurisprudence or legal understanding to include or to expand the term of refugees to climate refugees as well, it would be acceptable, but it will also be very broad to interpret just generally. And I don't know if it is better to say climate displaced people or climate migrants or climate refugees. I think I leave it to those in the higher up decision making as to what they want to call it. But I think these are more political terms, right? Which we often hear in the media terminologies to just create or accept or reject certain political movement that may or may not be arising in a particular political context. I think for now, I'll just go with climate displaced persons.
Thank you. That's very helpful.
And so the follow-up to your question is, wasn't Toshiyota a valuable step forward because it recognized the principle of non-refoulement as a measure to protect climate displaced people? Yes, like I said, Toshiyota, the challenge to Toshiyota is the application of the violation of right to life itself. So Toshiyota recognized application of non-refoulement under human rights violation and expanded right to life protection related principle of non-refoulement. But the challenge there would be to establish imminent threat. And it would be easier to establish imminent threat in cases of sudden onset disasters like earthquake, but it would be difficult to establish imminent threat in cases of sea level rise, or in cases of desertification, or in cases of glacier melting, and challenges arising out of these phenomenon because they are slow onset. And so the urgency to the threat of life would be difficult to prove. And that was the challenge in Toshiyota's case as well. That is exactly what the Human Rights Committee also said. It said, yes, we are ready to expand principle of non-refoulement to protect Toshiyota, to recognize Toshiyota as climate refugee, but we wouldn't do that because there is no ample evidence to prove that Toshiyota is facing a threat to his life because of climate change or sea level rise. And so when the court said that, the court was saying there's no imminent threat to right to life. And so I think that would remain a challenge for at least next 10 to 15 years, unless we emit a lot of fossil fuels and accelerate this process of sea level rise faster to 5 years. That's likely to happen. And so again, Professor Bhate, the follow-up to that question is, there's a great opportunity to adapt humanitarian visas and TPS to protect climate refugees. And now we just need political will to embrace it. And I really agree with it. I think there is a great time to adapt humanitarian visas. and TPS to protect climate refugees. In fact, if I can just go a little beyond the idea of climate refugee, is that a lot of scholars, academic scholars, are arguing for protection of these small island nations through what is known as a rented territory, the way it works like for the Vatican City. So Vatican City does not have a territory of its own. It has leased part of Roman Italy to create itself as a nation. And so if the small island nations are deterritorialized because of sea level rise or lose their land completely, maybe these visa opportunities or these humanitarian visa related frameworks could then be combined with some leasing framework in countries like Russia, Canada, United States, which have a lot of land, and they can lease a piece of their land to these countries to at least continue their sovereignty. Of course, there are additional futuristic challenges attached with it. But this is also given as a broader solution. And so we can go very creative and innovative with expanding the scope of humanitarian visas and TPS protection.
Yeah, my concern with a lot of the responses to displacement is that it's damage control at best. I think to really effectively address this problem on a global basis is to get ahead of it. The idea is that we're not doing much good just to resettle people who have been violently displaced and have to find somewhere else to live. It's better to proactively get them out of harm's way and find a way for them to be resettled safely and much more comfortably than in response to a imminent threat. So do you have any thoughts about that as to?
I agree with you, Professor. In fact, this is the best solution to protect people affected internally. And a lot of small island countries are already doing that. For example, Fiji launched its planned relocation, where it's relocated people who were at the coast, at the front line of sea level rise, relocated them more internally. And so at least they are protected for next 15 to 20 years if the sea level rise happens at an accelerated rate. And I totally agree with you when you say to remove people from harm's way is the best solution that we can offer both internally and for cross-border migrants as well. This may, however, be a little difficult for disasters like the Syrian Turkey earthquake, which are sudden in nature, cannot be predicted, and may be one of those rare, unpredictable events. In fact, I am currently in Delhi NCR, and yesterday we faced earthquake tremors here. And so the focal point was Tajikistan. And I was just sitting on my sofa at midnight. It was around midnight. I was just sitting on my sofa, and my sofa was experiencing tremors. The fan on the ceiling was swinging, and of course my father, he went out. He was panicking. He was like, "There's earthquake going on, Chhaya. What are you doing?" And I'm like, "I'm not moving. I'll perhaps just sit here, enjoy the tremors of the earthquake." I don't know what I was thinking, but it was an experience that, sudden unpredictable disasters can happen. And so in those situations, definitely planned relocation cannot be a solution. And so in some situations, we need to respond earlier. And in some situations, we'll need to respond post the disaster has happened, definitely.
Any other comments or questions from the audience? I just want to say how impressed I am with your knowledge of U.S. law. I wish I could say the same for my knowledge of the laws in India. So it's very impressive. I've been studying U.S. law.
I think the credit goes to Vermont Law School for teaching the both of us the environmental laws and the understanding of the US laws. So I think I'll give the credit to Vermont Law School.
I'm sure they'll be happy to take it. But You deserve more credit. Thank you very much for sharing these insights. I think it's prompted a great discussion. I know there are some of my students on this call who are working on or very much invested in the climate refugees issue. And so you've certainly given them a lot to work with. I'm going to encourage some of them to follow up with you with additional questions, especially the ones who are working on topics related to India. But it's just been such a pleasure having you share your wisdom with us and get us thinking realistically, but hopefully about this major global crisis we face and how the law can do more than it's doing, and hopefully a lot more. So we're just grateful for your thought leadership on this topic.
Thank you so much for this opportunity. I am super lucky to be delivering this presentation today. Thank you for this opportunity, Professor Bhate and Dean Scenario. I hope I can contribute more in future to the overall work on climate change at your university.
You've certainly convinced us that we want to do this. So we're building that bridge.
All right, thank you so much. So I'll take your leave for the presentation from this meeting then. Thank you.
Thank you.
Thank you so much, Chhaya.